Thank you for joining us for our special webinar today over the OSHA Emergency Temporary Standard. This is all very new, of course. There's the revised ETS that was passed by the board yesterday, and we are holding this webinar to apprise you of those developments and what is new and what you should really keep an eye on going forward. I'm pleased to be joined by my colleague Eric Conn, the chair of our OSHA practice at Conn Carey. And as context for today, we've had this very long ETS rulemaking process. It seems like it's gone on for years. It's been really most active since about last October. And we've had the initial draft, we've had the revisions, we've been working with an employer coalition on advocacy around that rulemaking, and every day there's been a new development, it seems like. So the good news today is we've had some positive changes to the rule. There's some changes that we're not so pleased with and others that we believe should have been changed. But we do have some positive outcomes from the revisions that we did want to address with you. And we have a clear revision that can be a roadmap for employers and how to deal with the ETS in the present time frame. In long term, we're hoping there will be a winding down of the ETS as we make even further progress with the pandemic. But just as a brief introduction, let's see. My name is Andrew Sommer. I'm a partner with Conn at the California office. My focus is on OSHA enforcement, representing employers in OSHA inspections and appeals, as well as leading coalition efforts in rulemaking, particularly around the ETS, as well as the wildfire smoke standard. I also have a practice in employment litigation involving wage and hour issues, as well as wrongful termination suits, and otherwise just advise employers on a variety of workplace issues, whether it be workplace safety or other employment-related topics.
Hey everybody, this is Eric Conn. I'm one of the founding partners at Conn Carey, and I chair the firm's workplace safety practice group. I'm a carpetbagger in terms of OSHA and California practice of law. I'm based in Washington, D.C. And lead our national practice. But really for the last few years, I've probably done more in California than just about anywhere else alongside Andrew. And really during this pandemic in particular, I've been pleased to co-chair our firm's COVID-19 task force, keeping an eye on the OSHA rulemaking, participating in the OSHA rulemaking, but also, the rulemakings in Virginia, Washington, and Oregon, and the National Office of Federal OSHA. I've practiced in this space for over 20 years now, exclusively in the area of workplace safety and health. And it's a pleasure to join you today. Thanks for joining us.
All right, so to start with our agenda for today, we're going to cover the initial ETS rulemaking process. Eric will discuss all of the twists and turns of this process, and there's been many, but we think it is helpful to provide you some context. And then Eric will discuss the general initial rulemaking process, the various efforts to revise the COVID ETS, there have been many. And then we'll continue on to discuss the very specific textual changes through the revised draft and what you should be aware of. And then that will also cover some FAQs that recently issued by DOSH over the revised draft. But why don't we just proceed with the initial ETS. I did want to mention that we will do our best to answer questions at the end of the webinar, given the number of registrants. We won't be able to cover all the questions, but we'll do our best.
Yeah, and so I'm going to kind of talk us through the rulemaking process, and I'm not going to spend a ton of time there. It's been an incredibly fascinating rulemaking process, but I know most of you are more interested in the nuts and bolts of the rule, what has changed from the original version to the current version that is in effect as of this moment. But it has been quite a saga. So we thought we would just share a little bit about the process itself. And that's, if we could skip over to the first slide here. And I don't have control of that, Andrew. So if you could push us along. This could not even fit on one slide, the timeline of this really bizarre rulemaking process. I mean, really, we go back to kind of January or February when that first cruise ship docked and all of a sudden COVID-19 had reached our shores here in the US. Several months passed with the pandemic picking up steam and, significant increases in cases and hospitalizations and deaths. And ultimately, a lot of eyes on federal OSHA. Were they going to adopt a rule that would be pushed out or require state plans like Cal OSHA to adopt a rule similarly? Fed OSHA declined to do that. They were even sued to be forced to issue an emergency standard at the Fed OSHA level, and they went into federal court and said, we don't need it. A rule's not necessary. This does not reflect a grave danger. And so Fed OSHA never did it. And Cal OSHA and a couple other states stepped up and said, well, we're going to lead if federal OSHA is not going to lead. And in response to a petition from WorkSafe to require the agency, Cal OSHA, to adopt, or requesting that Cal OSHA adopt an emergency standard and actually providing proposed text of an emergency standard, the Standards Board voted to grant that petition back in September. Pressed ahead within a couple of months to reveal to the public draft language for that ETS. And that language was very, very different from what WorkSafe had proposed. WorkSafe's petition included regulatory text that was very prescriptive. The draft proposed ETS back in November was a little bit more performance oriented with some prescriptive elements. The rulemaking process from that point got, really weird. It was one of these where they opened it up for public comment, but public comment was due on the same day that the board was convening to vote on the rule. And I know for a fact that there were written submissions, written comments that were delivered after the board meeting started. So it was impossible that the board could actually read public comment that was being offered, as they were voting on the rule. Each one of these meetings has gotten progressively more and more strange. Lots of public comment, extreme participation, incredible numbers of folks participating, either advocating for a rule, advocating against a rule, advocating for particular provisions or more reasonable provisions. But at the end of that meeting, the board voted unanimously to approve the rule. It went over to the Office of Administrative Law, which is like OMB, about a 10-day, usually a 10-day review period, where the ETS was ultimately approved right over Thanksgiving weekend back in 2020, and it went into effect immediately. And there were lots of problems with the rule. I mean, even the board sort of acknowledged that there were problems with the rule that they were voting in that would need to be addressed ultimately. And so one of the things that happened shortly after the rule went into effect is an advisory committee was convened. And in connection with the advisory committee, the division put together a discussion draft with some potential proposed changes that we might see with the rule. Conn, we organized a big coalition of employers and trade groups, submitted comments with the original draft of the rule, submitted comments to OAL. We participated on the advisory committee and submitted again written comments at the conclusion of the advisory committee process. And at the end of that process, in sort of middle of February, the board went back with all of the feedback from the advisory committee and public participants and introduced proposed ETS revision number 1. And that was in early May. And they convened a board meeting to consider proposed revisions in, we'll call it ETS revision number 1 on May 20th. And there was substantial written comments submitted about the proposed ETS revisions. And there was substantial public participation in a hearing about that. And the outcry by industry was that these revisions largely were sort of stunning. They went the wrong direction. The idea was that there were, aspects of the rule that were very problematic, that were very onerous, that were unnecessary, and somehow the proposed ETS revision number 1 made the rule in many respects worse. But in any event, they set about to consider that proposed rule, and right before, I guess it was right before the board was about to convene to hear those revisions. Recall that it was, I think, May 13th, so a week before that board meeting, that the CDC issued its very significant updated guidance about relaxing requirements for fully vaccinated workers. And obviously the ETS revisions number 1 did not do that. There was really no relaxing of provisions in that proposed revision to the ETS. So right before the board was to consider those, the division pulled back and canceled. They asked the Standards Board to cancel that meeting because the purportedly to consider the CDC's update and to update their proposed revisions. So they did. They canceled that meeting. The division went back and introduced a new version of a revised ETS. We'll call it revised ETS number 2. And the board met to consider that updated version. And somehow, again, very surprisingly and disappointingly, Cal OSHA, the division asked to cancel that board meeting so that they could adjust the rule based on the CDC guidance. And then they didn't do it. ETS version number 2, revised version number 2, still did not account for vaccinated workers in the way the CDC had. They basically introduced the concept that if every single person in the workplace is vaccinated, you can make changes, but which is probably an impossibility in almost every workplace in the state. So there was outcry about that, but nevertheless, the agency voted to first voted down the rule. Said they'd also introduced this N95 requirement that was very problematic. Voted it down, then took a break, and behind the scenes, I think, talked about some practical problems with voting down the ETS. Convened again and voted to adopt it, even though they had just voted it down. But they also voted to impanel a subcommittee to consider additional revisions and dig back into the rule and introduce a new revised version shortly after. Then a few days after that, either from pressure from the governor or just coincidentally, CDPH issued its own, or was prepared to issue its own big update based on the CDC guidance. And I think from a practical standpoint, realizing that because of this, the weird rulemaking concept in emergency rulemaking, that you can only re-up or re-adopt a rule twice before you have to do a permanent rule. The board scrambled to announce a special meeting to consider the new CDPH guidance and also to claw back the ETS revision that had just been sent to OAL before OAL approved it, because they didn't want to lose one of those 2 bites at the apple for a readoption. So they clawed it back. OAL did not vote to approve it, so there was no revision to the ETS in that early June period. We were back to the original ETS, but this time they got back together, rewrote the rule once again, and this time did really account for the big changes from CDC guidance, the big changes from CDPH guidance, and the realization that cases where the landscape was very different, and Governor Newsom had a plan to reopen the state on June 15th, which was not compatible at all with the revisions that the board had just voted on. So DOSH distributes an updated draft. We'll call this revised ETS number 3. And even before the Standards Board met to vote on that yesterday, issued some FAQs. At this meeting yesterday, the board did vote to adopt ETS number 3. And shortly after the close of that meeting, Governor Newsom signed an executive order that basically canceled the OAL review period to allow those revisions in ETS number 3 to go into effect immediately. It was right after, I think, the updated version that had just been voted on was published in the public record in California, and that happened shortly after the meeting as well. So as of yesterday afternoon, ETS revision number 3 was published. immediately in effect, courtesy of Governor Newsom's executive order. And that's where we are today. So we're going to talk now sort of substantively, nuts and bolts, about what was in the original rule and what has changed and what is in effect as of today.
And I was just going to add that, I know in the advisory committee, there was really extensive discussion over vaccinations and what that will mean for the ETS. And we believe that there would be a significant change in the ETS to address that. And initially, there wasn't much that was done. And we really thought that when the second draft of the ETS revision came out, it would be much more constructive, much more significant in addressing face coverings and physical distancing and other requirements for folks that are fully vaccinated. But ultimately, it didn't, as we all saw. And ETS number 2 did not meaningfully address the status of vaccination. And then it took, whatever happened behind the scenes, we ultimately got to the point of having ETS number 3. But it's been quite a saga. We now have some relative finality over the revised version. We'll see what comes in the future. But
there was a question I just saw from a process standpoint. Does this even count as a readoption because of the sort of intervention of Governor Newsom, that executive order? In my view, it does. It's not that Governor Newsom sort of adopted ETS revision number 3 by executive order. The Standards Board met, the Standards Board voted to adopt it, and all Governor Newsom did was forego the OAL review period. So in our view, that counts as one of the 2 adoptions because it was voted on by the board as a readoption. That's our view of that. Again, I'm going to move really quickly through the original ETS nuts and bolts because I think what everybody really cares about now is what changed in the rule. So let's just kind of move through this quickly. The initial concept here, and this changed very little in the readopted version yesterday. Concept is the ETS basically applies to all workplaces in the state of California, except for workplaces that are covered by the pre-existing aerosol transmissible disease standard, the ATD standard, which is generally speaking a healthcare workplace standard. So if you're not covered by the ATD, you're covered by the ETS without regard to size or any other aspects of the nature of your business. The only other caveat there is that the standard or none of the provisions of the standard apply to telework work that is done from employees' homes. And of course, the ETS did not limit any other more protective or more stringent state or local health department mandates. And that has been one of the great challenges for employers all over the country, but in particular in California, is dealing with the patchwork of health department requirements, governor's mandates, and OSHA agency standards, and no exception at all in California, for sure, in that regard. Next, after application, is what's required under the rule. The sort of cornerstone or foundational component of the ETS is the COVID-19 prevention program. And this is basically a COVID-specific IIPP. The requirements are have a written program. The program includes your policies regarding notice to employees and others who are close contacts or who experience a close contact exposure. The written program is to lay out your policies for dealing with physical distancing and separating employees by at least 6 feet whenever possible, and providing and ensuring employees wear face coverings. In the original rule, it was basically every indoor setting and outdoors if you couldn't maintain distancing. The written program was to identify all of the engineering and administrative controls that you would be implementing to deal with the spread of the pandemic in the workplace. It included some reporting and recording requirements, and the pay and benefits continuation elements of the rule needed to be in your written program. Let's see what we've got next. The outbreaks provisions. This was probably the most controversial of the provisions in the original rule. as written originally and without the help of some FAQs that were basically rewriting the rule. The outbreak provisions were terrible provisions, in my opinion. There was no accounting at all for work relatedness. So they're basically declaring something an outbreak if you had 3 or more positive cases, even if they were demonstrably not spread within the workplace. So it's an outbreak, even though it's not breaking out at work. But when that happens, there's this requirement to do extensive testing for potentially large group of employees, potentially all employees at the workplace, the way the rule was originally written, though that was crafted and narrowed a little bit by FAQs throughout the process. And I know Andrew's going to get into what has changed about that, so I'm not going to go super detailed about the outbreaks provision as originally written, because we're going to talk about what they require now, which is really all that matters. On the next slide, the sort of final component, sort of the last block of requirements under the ETS applied to employer-provided housing and transportation. And in this context, that you needed to take this during, what might be considered non-work time. If you are providing housing or transportation in connection with work, need to implement COVID protocols to protect employees in those settings where the employer has some control. And there were some changes in this regard as well in the updated ETS. So I'll leave it to Andrew to kind of get into the nuts and bolts of that, because all that really matters is what's required today. And I think that's it. And Andrew's going to really, carry the day today and talk about what you need to know today and going forward with this emergency rule.
All right, thank you, Eric. I wanted to cover the highlights of the revised draft that was adopted yesterday. And so we're going to discuss the significant updates. There are a number of nominal changes with language usage. We're going to focus on what's really meaningful and departs from the prior draft. So the second revision to the ETS did retain physical distancing through the end of July. And that, did cause some consternation after that version was withdrawn. And the third version, the June version issued, that version now deletes any physical distancing requirements as of the present. So there is no requirement for physical distancing in the ETS. The caveat to that is, however, that if you have an outbreak situation or a major outbreak, you will need to consider physical distancing. It's really something you need to evaluate in the context of a outbreak, but in a major outbreak situation, physical distancing will be required where you cannot maintain, or it will be required to the extent feasible. And then the next major change in the revised draft concerns face coverings. And the prior, as Eric mentioned, the initial ETS did require face coverings for all workers indoors or outdoors where they could not maintain physical distancing. Now there's a two-pronged approach. One is if employees are fully vaccinated, they're not required to wear face coverings. And I will address in a moment what is required to establish for fully vaccinated workers before you can essentially not require face coverings. But for employees that are not fully vaccinated, they are required to wear face coverings, to wear masks, both indoors and when in vehicles. There is no requirement anymore for wearing face coverings outdoors. And then there are some very limited exceptions that have also been written into the ETS for face coverings. There is a new definition of face covering, and that definition requires 2 layers of material or fabric. And the new definition does expressly state that a face covering is not a scarf, ski mask, balaclava, if I can pronounce it correctly, bandana, turtleneck, or collar. So that's something to keep in mind. And then going to the definitions. Oh, yes.
One thing that's worth noting there is that in the original, the first 2 versions of the ETS revisions gaiters have been explicitly called out as not acceptable forms of face coverings. And with some pushback and lots of questions and encouragement, that is such a popular version of a face covering that was removed from this updated version. The concept, though, is, and I know, we talked to folks at Cal OSHA about this, is if you're going to use a gaiter, it should be folded over to be 2 layers. And it's acceptable if you wear it that way, but not if it's just a single layer.
And, I would just add that, there is some ambiguity around that with gaiters, and you could have differing positions taken by compliance officers at Cal OSHA, but we have informally received some guidance that would, as Eric said, that would indicate that gaiters would be adequate as long as you have the 2 layers. And then for face coverings not to be required for employees, they need to be fully vaccinated. And that is based on the definition of fully vaccinated under the ETS. And that definition involves, specifically states that the employer has documented that the person received at least 14 days prior, either the second dose in a 2-dose vaccine or the single dose vaccine. And the new definition of fully vaccinated does recognize that international vaccines administered outside of the United States and approved by World Health Organization are recognized, which is helpful for international employers. And then there were some frequently asked questions that issued just recently by DOSH that provide some guidance about what proof of vaccination means. What does the employer need? And so they provide essentially 3 options. One is that the employer may receive proof of vaccination. And so that could be a vaccine card as an example, and the employer could retain a copy of that vaccine card. The other option is that the employee can provide proof of vaccination and the employer maintains some sort of record other than the vaccine card as proof of vaccination, or as their record of the vaccination. And the third option is some sort of self-attestation of vaccination status by the employee that the employer maintains. And that could be similar to the form that is required in the County of Santa Clara by the local health department. But one important point, Eric may be raising this right now, but there is a requirement to maintain medical records. And so we've been really wrangling with that. Eric has much more guidance on this, particularly from the Fed OSHA standpoints. I'll allow him to address that.
Yeah, so we're trying to get clear answers. We're trying to advocate for specific answers and to get clear answers from Cal OSHA about this, and they've dodged the question to this point. I'll share my view of what I think the answer is based on the regulation and based on the way the regulation has been implemented over the years, COVID notwithstanding, is that my sense is that if you collect the actual vaccine card, that is an employee medical record that would have to be maintained for 30 plus years under the medical record regulation. If you, however, collect information in one of these other 2 forms where the person who is documenting it is not a professional medical provider, that it would not trigger the requirements of the preservation. You should still, for a lot of reasons, maintain confidentiality of that information, whether it is covered by the employee medical record rule or not. But we don't believe there is going to be a 30-year preservation requirement if you are an HR representative, a supervisor who's not a nurse or a doctor is just writing down the employee's answer to the question, or if the employee is self-attesting, filling out their own form about their status, and they are not a doctor or a nurse, that is confidential information, but it doesn't trigger the preservation requirements. But this is Eric Conn's opinion on that, and we're working on getting a specific FAQ about that. In fact, we're trying to get the agency to say, regardless of whether it would ordinarily be treated as a medical record that has to be preserved, that it doesn't have the 30-year preservation, no matter what form you take here, even if you take the card. But at the very least, it should be clear that these other two are not. So that's the best we can say today.
All right, and so the next issue is around respirators. And this was a new requirement. It was inserted into draft 3 of the revisions. And this is an area of significant concern to employers. And we did, I think it first arose in draft 2, and in draft 3, there was language that was inserted upon request that seemed to give some leeway to employers to have a lag time for providing respirators. But the requirement is essentially that upon request, employers must provide for voluntary use respirators to employees who are not fully vaccinated and who are working indoors or in vehicles with more than one person. And the good news is that this is for voluntary use. So under section 5141 regarding harmful exposures, it doesn't trigger the requirement for fit testing and medical evaluations that otherwise would apply for mandatory use respirators. And so with the upon request, what came to mind was, so you have to so a respirator could be, for example, an N95 respirator, a powered respirator, but for all intents and purposes, we're talking about N95 respirators. OSHA does not recognize KN95 respirators as an adequate substitute. So we're really talking about the precious N95s that there's been a limited availability of. And so upon request, that has been interpreted under the new FAQ as meaning as soon as possible. So what does that get us? It really doesn't get us anything because that means you have to have these respirators already in stock. But there are a couple comments in the guidance documents that help us in a way navigate this issue. One is DOSH takes a view that employers may either just stock up on respirators, or they may poll workers to determine how many will want respirators before obtaining them. So if you have concerns about stocking up on too many respirators or not having enough, one option may be to just poll your workers. It could be simply an email to the workforce and figure out who may need them. I mean, we suspect that many that are unvaccinated will not want a very uncomfortable N95 in place of a regular face covering. But at least you could then get a sense of what the interest is and then make your orders accordingly. The other guidance from DOSH is that once the employer establishes that employees wish to wear respirators, it must stock enough of the correct size and type to fulfill any requests that in the future. Now, what is the correct size and type? So you need to look at a variety of different options that could work for your workforce. And that's one area that we've been pushing back on, that we've really wanted or desire not to be in the rule. And then there's one FAQ that's really peculiar because it states that if an employee prefers to select and purchase their own respirator, an employer may permit this alternative as long as the employer reimburses the employee in a timely manner. There is no requirement in the OSHA regulations concerning PPE for an employer to pay for PPE that's selected by an employee. So we believe this is setting a bad precedent, but this is something to be aware of, at least in the guidance document. It doesn't require you to accept the PPE selection or the respirator selection of the employee in this case, and you can simply provide your own that you paid for. And so related to this respirator requirement, the employer must provide training, including the policies you have on providing respirators. It also includes how to properly wear the respirator, how to perform a operator seal check, the fact that facial hair interferes with the seal. But there is no requirement to conduct a fit test that's consistent with 5144 or 41 regarding mandatory respirators or medical evaluations, but there is this more generalized training requirement that's in the ETS itself. But do note that when you have an outbreak situation, there are additional requirements regarding respirator use that will be triggered that I will cover in a moment. There was sort of a bone that was thrown to employers here by recent guidance by DOSH, stating that Cal OSHA will not cite employers who make a good faith estimate and effort to provide respirators as soon as possible, meaning that if you cannot obtain these respirators reasonably upon request by employees, that might be a defense you could assert to avoid a citation. This is just a representation by DOSH, and they could do something entirely different. But my recommendation, something to consider, is that if you find that you don't have access to the respirators as you like, this is something that that'll be really important for you to document. Document your initial efforts, whether to poll employees or get a sense of what the demand is for 95 respirators. And then later, if you find that you're running out and there's supply chain issues, to then document your efforts to obtain respirators in the general market. There is an effort by the governor's office to provide access to employers, which I understand is free of cost. A lot of it's being administered through the California Chamber of Commerce and their affiliates. But there is a site, and I will type it into the chat box at the end of the webinar, and you can go to your local county there and obtain respirators. We don't know for how long these will be available, but that is the current program. And then another really significant change that we're pleased by is this question of partitions for fixed workstations, like you would see at pharmacies and grocery stores. This is an area where Cal OSHA has been real enforcement heavy in a way that we believe has not been reasonable given the nature of the spread of the disease. And there has been this insistence on partitions of a certain configuration. This is by Cal OSHA. And the positive development here is that the requirement to install these partitions in the workplace has been deleted altogether. However, if there is an outbreak, you must evaluate whether to reinstitute physical distancing, and where that's not feasible, use partitions. And in major outbreak situations, you must install partitions for fixed workstations where physical distancing is not maintained. And of course, that presents a major issue. Is if you have a major outbreak, then you're likely not going to have the time to quickly install the partitions. And that is a an issue that could potentially arise, but you just need to be aware of this. Okay, so the next issue is exclusion pay. That has been in the original ETS, and as many of you know, exclusion pay relates to the time away from work where employees need to be excluded because they are COVID-19 cases, meaning that they're positive for COVID, or that they have a close contact with someone that is COVID-19 positive in the workplace. And so there are exceptions now for this exclusion pay requirement, and that includes employees who are fully vaccinated before the close contact. So if they have a close contact, but they're fully vaccinated and they are asymptomatic for COVID-19, they do not need to be excluded from the workplace, and they do not need to be paid exclusion pay. The problem that we encounter is that the definition of symptomatic is so broad, it includes a whole host of symptoms that could be related to the common cold or allergies, so it presents issues. And we'll see how that manifests itself in the future in Cal OSHA enforcement. And then the other exception is really just if someone had previously tested positive for COVID, was infectious, and had recovered under certain circumstances, they might fall under this exception and not be excluded from the workplace and not entitled to exclusion pay. The one addition in the latest draft that causes us significant concern that you really need to be aware of is around enforcement of exclusion pay provisions under the Cal OSHA rule. And so typically there are not enforcement mechanisms outside of Cal OSHA to enforce its terms, but here they have inserted that wages are subject to enforcement through procedures available under existing law. So what that means is that you can have an employee bringing a claim with the labor commissioner. They could bring a claim in court seeking wages for exclusion pay and attorney's fees. And this could occur as in an individual lawsuit or in a collective lawsuit, including a PAGA lawsuit. So it's going to be really important to track the cases that might trigger exclusion pay and ensure that you're paying that wage continuation as appropriate to avoid that type of exposure that would be quite significant. And then this revised draft also incorporates the executive order shortening the close contact exclusion pay period from 14 to 10 days for close contacts generally. So let's also address the notice requirements. This will be less impactful than the other provisions because this notice requirement largely tracks AB 685 that many of you should be aware of. The existing or the prior requirement in the ETS was to provide notice to close contacts of potential exposure. And that was removed. And in its place, there is this AB 685-like requirement that you provide written notice within 1 business day to all employees and their union at the worksite who were at the worksite during the high-risk exposure period, and also to independent contractors and other employers that were at the worksite during this high-risk exposure period. And the high-risk exposure period is essentially the infectious period. There's a unique definition for that. Worksite is like the definition under AB 685. So you're focused on the location where a COVID-19 case was present during the high-risk exposure period. So it does not apply to buildings, floors, or other locations where the COVID-19 case did not enter. So you could be focused on a specific floor of a building, one building of many. You're not looking at the entire workplace to figure out where the notice is. But the notice is broad. The notice is broader than close contact. So there could be individuals that had no close contact, but they would still be entitled to this notice. Okay, so let's move to outbreaks and major outbreaks. As Eric mentioned, there's no work-relatedness analysis for outbreaks, which is something that we had addressed during the rulemaking process in our comments. And so you could have cases where you have multiple workers that contracted COVID clearly outside of the workplace, but just by the mere fact that they're in the same exposed group in the workplace during a certain time frame could trigger an outbreak situation. So this is something we still need to be very much aware of. The one positive development on the latest revised draft is that it includes the insertion of employee for COVID cases. So you have to have 3 or more employee COVID cases. So you're not looking at members of the general public, individuals that are outside of your workforce. So if you have 3 or more employee COVID cases within an exposed work group that visited the workplace within the high-risk exposure period and in a 14-day period, that could trigger an outbreak. And there is a new definition. It's for exposed group, and it replaces exposed workplace that was previously used in the UTS. And that definition provides that all employees at a work location, working area, or common area at work, and it is where the COVID-19 case was present. And there are some exceptions or clarifications in the FAQs that focus on momentary passing through an area where everyone is wearing face coverings, and that would not be considered for the purposes of the outbreak determination. Given the lessening of face coverings, I don't see that exception really being that relevant here, but we're really looking at what is the work location and looking at whether within that work location where the COVID-19 case was present, whether you have the minimum or 3 cases. And so this is a highly factual analysis. It requires some really thoughtful analysis because the consequence is great. You want to make the right decision, determine whether it's an outbreak, but you don't want to err on the side of classifying as an outbreak and then be required to comply with all of these additional really onerous mandates. And so some of the additional requirements, if you are in an outbreak situation, involve face coverings, evaluating physical distancing, barriers, and also enhancing your air filtration system if you do have mechanical ventilation. And that requires having MERV 13 rating ventilation or filtration or a higher efficiency filter. And then the other area, this is also on testing, employers must make COVID-19 testing available at no cost during an outbreak. And exceptions to the testing requirements are for employees not present at the workplace during the relevant 14-day period for the outbreak determination. Fully vaccinated employees who do not have COVID symptoms, and asymptomatic COVID cases who have returned to work who were previously infected or tested positive for COVID and were within this window of 90 days. That's it, just very generally. And then for major outbreaks, that, as you may be aware, is a much higher threshold than the outbreak standard, and that requires that you have 20 or more employee COVID cases, and that standard was changed to insert the word employee to focus on your workforce for identifying the 20 cases, and then also using the exposed group definition that replaces the prior definition. It is the time frame under the existing standards, a 30-day period for assessing whether there is a major outbreak and you have the minimum 20 cases. And then just very briefly, there's various different testing requirements. A very significant difference with a major outbreak is you must provide respirators for voluntary use to exposed employees. Physical distancing requirements apply. And as I mentioned previously, you are required to install partitions where you can't maintain distancing. Okay, so we're going to breeze through the last couple slides and we'll leave time for questions here. The last two sections involve employer-provided housing and employer-provided transportation. The changes there were not as significant as under the general COVID-19 prevention section, but there were a few noteworthy changes, and one is that the section no longer applies to housing where all residents are fully vaccinated, and then physical distancing requirements have been removed. The ventilation requirements are more specific. There's some additional cleaning requirements, and then exceptions from quarantine requirements for asymptomatic, fully vaccinated residents and certain COVID cases. And then for employer-provided transportation, this provision, just like the housing one, does not apply to vehicles in which all employees are fully vaccinated. The physical distancing requirements have been removed as well. Face coverings must be provided and worn by all employees who are not fully vaccinated and are in that transportation. The section was also revised to suggest that this does not apply to commuting and that you're really focused on transportation within the course of employment to and from different employer sites, as an example. And then upon request, employers must provide respirators for voluntary use. And then there's some additional cleaning requirements. And so we have much additional information on our website. And we have a COVID-19 task force with a variety of information, as well as with our blogs, which you can access. And we've been blogging quite extensively on COVID-19. I can't even recall what was yesterday in our blog post,